is what it reads. And finally, the topic for today's discourse and discussion is uh, greatly interesting. Uh, Even the topic is very interesting because that requires some explanation before I begin my talk today. The topic is criminal justice in India, primitivism to postmodernism. Now, it's about criminal justice in India. And in 90 minutes' time, I have to cover this distance from primitivism to postmodernism. Now, every one of you are already aware of what the idea of postmodernism is, or what is meant by postmodernism. Still, few observations, few comments, few quotes from here and there would not be out of place, and same goes for the idea of primitivism as well. Now, India as a civilization has completed, by certain estimates, of course, has completed 5,000 years of its existence. So, which society do you call a primitive society in the Indian context? Which society? And as far as postmodern Indian society is concerned, certainly there are lesser points of disagreement as to which society, which Indian society would be a postmodern society. Now, when it comes to criminal justice in England, or for that matter in continental European countries, there is abundant literature available. Abundant literature. I believe that you must have heard of that classic ancient law that was written by Sir Henry Maine. Henry Maine wrote that book, classic, of course, declared to be classic immediately after its publication in 1861. And what is very interesting about ancient law, it's available online, meaning thereby the e-copy can be had without much hassle. You just type ancient law in your browser, mention the name of the author, Sir Henry Maine, add PDF, and of course you would have certain links from where you can have a free download. It's not possible to discuss in entirety what Henry Maine has written and in what context the book titled Ancient Law, which has completed more than 160 years of its existence. What is very interesting about the book and the author is that Sir Henry Maine was born in India in 1822. His father was serving the East India Company and he was born in India, though he was sort of sent to Cambridge to obtain his degree in law and all. He eventually became a professor of civil law at Cambridge and was also a member of Indian Council for 7 years and died in 1888. When you read ancient law, especially chapter 10 of that's the last chapter of the book, Ancient Law. He is talking about the development of criminal law and institutions in the continent, not in Asia. He is not talking about the Asian societies. He's talking about the European societies. He's talking about the German society. He's talking about French. He's talking about English. He's talking about institutions in both civil law jurisdictions and common law jurisdiction. But what is missing in ancient law is any reference to India. Any reference to India. And what he has claimed in ancient law, of course, a thoroughly researched work. It's not a fiction, it's not a figment of imagination, or it's not a philosophical work. It's not about legal philosophy. Let me make it very clear. It's about legal history. And he goes back to the dark age and then the medieval European history, and certainly he's talking about the law and legal institutions in the 19th century. Europe, with a special reference to England. So his claim, if I have to sort of tell you that what is the claim that he has made. On the question of criminal justice system, its shape, its functioning, or criminal law for that matter. That claim can be summarized in just one sentence. He says that it was law of wrongs and not law of crimes in the primitive societies. Law of wrongs, the distinction between what we today call crime and what you today call civil wrongs or torts, notwithstanding that debate between torts. There was no distinction. So what is the ground for making such claim? And that claim is very well founded, of course. Was that the idea of crime that we have today as a wrong against the society at large, or as a wrong against the state, was missing in what he claims the primitive European societies. All wrongs were taken to be private wrongs, and everyone was free to pursue whatever remedy one may, including taking of another's life. It was later when the state started exerting its might that it took unto itself the task of punishing people for certain serious wrongs, very serious wrongs, like murder, like theft, and then many others. Was it so in the so-called primitive Indian society as well? Was there no distinction between what we today call crime and tort? Is a question that we need to look into and also try to find an answer to. Now in India, even today, you have legal texts that date back to many centuries before this modern age began. This modern age began. And it would be illuminating to look into what was the state of criminal justice and whether there was any system that may be compared with the modern criminal justice system that you find today the civilized in the civilized societies. Ancient criminal justice system in India makes a very, very fascinating reading and requires the scholar, requires the one who is interested in knowing what was the state of affairs as far as so-called primitive Indian societies are concerned on the question of criminal justice. These classics like ancient law, or for that matter other writings which are all in public domain today, would be of little help. So what I would be doing is that I would be giving you some glimpse into the criminal justice system in ancient India. And let me start with the constitution of courts. Constitution of courts in ancient India. In ancient India, it has been written by legal historians that king was regarded as the fountainhead of justice. King. And his foremost duty was to protect his subjects. He was respected as the Lord of Dharma. And was entrusted with the supreme authority of the administration of justice in his kingdom. The king's court was the highest court of appeal, of course, not the court of first instance in every case, but in certain cases it was also an original court in case of vital importance to the state. Does that sound primitive? Does that sound primitive? Even the Supreme Court today, though essentially the highest court of appeal, is empowered to exercise original jurisdiction in certain vital importance, in certain matters of vital importance to the state and also to the individual. And it was not that the king in ancient India, who was the fountainhead, as I said, of justice, would be acting and would be deciding on his whims and fancies. Rather, in the king's court, the king would be advised by learned people. Chief Justice, other judges, ministers, elders, representatives of the even trading community. And there was a clear hierarchy, in fact. There was a clear hierarchy. It's not that. If you read History of Dharma Shastra by P.V. Kane, P.V. Kane is one of the most erudite and great scholar of ancient Indian legal history and legal institutions. Ancient Indian legal history and legal institutions. And his History of Dharma Shastra, which is in multiple volumes, has several illuminating chapters and texts. Law and administration of justice. You can also refer to one article that was written by Justice S.S. Dhawan, titled Indian Jurisprudence. Indian Jurisprudence. That was written way back in 1963. But of course, historical accounts never lose their sheen and shine and relevance and importance, of course. So notwithstanding that was in 60s, 1960s, of course. S.S. Dhawan's article titled Indian Jurisprudence is still relevant and very insightful for understanding the administration of justice in ancient India. So next to the King's Court was the Court of Chief Justice. That would have not only a judge who would be first amongst the equals. This is how we see the Chief Justice of India even today. Or for that matter, the Chief Justice in other jurisdictions. So the Chief Justice's court would consist of a board of judges to assist him. The only flip side was that all the judges would be from the three upper castes, preferably the Brahmins. There were also tribunals, separate tribunals having a specified territorial jurisdiction. Brihaspati's writings are again very illuminating to understand the state of affairs as far as the administration of justice in ancient India is concerned. He has stated that there were four kinds of tribunals, namely the stationary, movable courts, commissions under the king's presidency, there was a decentralization of these judicial tribunals as well. For example, in villages, there were local village councils similar to modern panchayats. Modern, you have modern panchayats. Criminal cases, we are specifically concerned with the criminal cases. Criminal cases were ordinarily presented before the central court or the courts held under the royal authority. And smaller judicial assemblies at the village level was allowed to hear only minor criminal cases. Minor criminal cases. Aren't we getting back to the same kind of arrangement even in 21st, 21st century? When you look at the hierarchy of courts in this country, if I ask you that how do you describe the hierarchy of courts in this country, and you start from the top, the Supreme Court of India, and when you get down to the bottom, you find that Gram Nyayalayas are at the bottom of that hierarchy. And it has also been pointed out that even in ancient India, the decision of each higher court superseded that of the court below. Isn't that what you find in the modern legal systems of today? Then each lower court showed full respect to the decisions of each higher court. And as such, the king's decision was supreme. As such, today, the decision of the Supreme Court is supreme. Remember what the Constitution says, that the decision of the Supreme Court of India is binding on all the courts below. So, in a primitive society, you have glimpses of modern criminal justice system. In a primitive society, compare that with, I again say, compare that with what Sir Henry Maine has written about the ancient European society. In the ancient Indian society, one of the cardinal rules of the administration of justice was that justice should not be administered by a single individual. A bench of two or more judges was always preferred to administer justice. No decision shall be given by a person singly is a formula that you would find frequently repeated in the old text. Vashishta has been quoted by Kane and Rama Joyce and other legal historians who have focused on ancient Indian law. Vashishta says, let the king or his ministers transact the business on the bench. So were there lawyers as well, as far as the criminal justice system in ancient India is concerned? Smritis don't refer to the existence of any separate institution of lawyers in the ancient Indian judicial system. The Smritis don't refer to. But Kane has written, P.V. Kane again, in that book, History of Dharma Shastra, in volume 3rd, yes, that this does not preclude the idea that persons well versed in the laws of the smritis and the procedure of the courts were appointed to represent a party and place his case before the court. He has also observed that the procedure that has been prescribed by uh, the smritis, especially the Narada smriti, the smriti of Katyayan, the smriti of Brihaspati, reaches a very high level of technicality. And for that reason, skilled help must often have been required in litigation. Let me explain this a little further. There are several tribunals where representation through a lawyer is not mandatory. In the regular court proceedings, of course, representation through a lawyer, especially in a criminal justice, of course, one can argue his own case, but the procedure is so technical that skilled help is required. Even if one is thorough with the theoretical aspect with law, the procedural technicalities would necessitate skilled help. Even law professors would require lawyers to represent their case in a court of law, especially in a criminal case. The many tribunals today where representation through lawyers is not necessary, but then the procedure is so technical that you can't afford to go alone. You can't afford to present your case when the other party is being represented by a lawyer. Now, coming to the judicial procedure was very elaborate. I'm talking about the primitive Indian society. It was very elaborate. We are not concerned with the civil procedure, of course, but even the criminal procedure was very elaborate. I would be focusing on the criminal procedure. In criminal cases, sometimes circumstantial evidence was sufficient to punish the criminal or to acquit him. Circumstantial. Look at what is the principle as far as burden of proof is concerned, as far as the sufficiency of evidence is concerned. Remember your LLB days when you had discussed that even circumstantial evidence is, if the chain of circumstances is complete and there is no missing link, even a case of murder, or for that matter, any other heinous offense, may be proved on the basis of circumstantial evidence. And when it comes to sentencing, this aspect of sentencing as well, which can't be missed out in cases which are based on circumstantial evidence. In a catena of cases, the Supreme Court said that it's unsafe to award death penalty in a case based on circumstantial evidence. Then they developed that doctrine of a residual doubt. Residual doubt doctrine is borrowed from American jurisprudence, American criminal uh, jurisprudence and was applied in several cases in India to justify life imprisonment and a preference to life imprisonment over death penalty. But the trend has changed. The Supreme Court has now started saying that the doctrine or the theory of residual doubt is an insane theory. And when we have this proposition now very well entrenched in our criminal justice system, that a case founded on circumstantial evidence is no less than a case which is founded on direct evidence, and the only requirement is that circumstantial evidence must form a complete chain. So when circumstantial evidences form a complete chain, of course, no doubt remains about the guilt. So where is the question of that residual doubt, which is often invoked to justify the preference for life imprisonment? So in criminal cases in ancient India, circumstantial evidence was sufficient to punish. Circumstantial evidence would be sufficient to acquit as well. The accused was allowed to produce any witness in his defense before the court to prove his innocence. Of course, you have witnesses were required to take an oath before the court. Witnesses are required to take oath even today. In criminal cases, the courts were enjoined to convict only according to the procedure established by law. In criminal cases, the courts are enjoined to convict only according to the procedure established by law. You are aware, those who have practiced or those who have witnessed the court proceedings or have interacted with lawyers, closely interacted with lawyers, they know that much of the issues, many issues that the courts consider are majorly procedural in nature. Fabrication of evidence, false witnesses are not problems of modern criminal justice system, are not problems that only the postmodern societies are facing. False witnesses, even then, were very severely punished by the courts. False witnesses were very severely punished. You know that false evidence may even lead to death penalty. And this is what Lord Macaulay had prescribed in 1860 itself. The later amendments as well in the scheme of IPC and CRPC dealing with false witnesses again prescribe very severe punishment. False witnesses were very severely fined by the courts in ancient. Narada says that they were condemned, those false witnesses were condemned to go to horrible hell. Of course. People believed in the concept of hell and heaven then. People believe in the concept of hell and heaven even today. But then it was not all modern in the primitive setup. Trial was by ordeal. Trial by ordeal was a method to determine the guilt of the person. So the ancient Indian society, which was largely dominated by religion and faith in God, considered the trial by ordeal as a valid method of proof. It was very common, very common. to call upon the gods to witness the truth of a statement, as is clear from various illustrations that you find of the ordeals given in the epics, Ramayana, Mahabharata. The Smriti writers generally limited its application to the cases where any concrete evidence on either side was not available. Now, this is a later development. Smriti writers generally limited its application. So even if you believe that these epics are a work of fiction, I'm not into that debate, of course. I'm not here to test your faith and belief and all. But the Smritis are not work of fiction. The Smriti writers have given the account, the true account of administration of justice, the state of politics, of their times, and also guiding principles for future and all. So Smriti writers, be it Manu Smriti, be it the Smriti of other great sages and jurists, they limited the application of trial by ordeal to cases where any concrete evidence on either side was not available. If there was concrete evidence available, certainly the trial by ordeal was not an option, would not be preferred. Trial by ordeal was in fact primitive method. No modern society would accept this today. It was in fact primitive. In many Puranas, for example in Agni Purana, Agni, in Manu Smriti, a detailed account of ordeals as they existed in ancient India has been given. But it also points out that only in case of high treason or very serious offenses, the trial by ordeal was used. In other petty matters, it was sufficient to prove the truth by taking an oath. People were honest. They would be swearing and would be sort of accepting. If they have in fact committed crime. So it was modern in certain ways, but it was also primitive. It was also primitive in many other senses. Many other senses. This is what you need to understand as far as the ancient Indian society, is concerned. And look at what Henry Maine has written in chapter 10, which is titled The Early History of Delict and Crime. And he starts with the Teutonic codes. And allow me to quote the first paragraph that he has written in chapter 10. And it goes like this: the Teutonic codes, including those of our Anglo-Saxon ancestors, are the only bodies of archaic secular law which have come down to us in such a state that we can form an exact notion of their original dimensions. He also mentions that in the German courts, the civil part of the law, civil part, civil disputes, for example, has trifling dimensions as compared with the criminal. He, he says. And he also mentions that all civilized systems agree in drawing a distinction between offense against the state or community and offense against the individual, and the two classes of injuries thus kept apart. I may here, without pretending that the terms have always been employed consistently in the jurisprudence, call crimes and wrongs crimina and delicta. And he concludes, as I already said, now the penal law of ancient communities is not the law of crimes, it is the law of wrongs, or to use the English technical word, of torts. The person injured proceeds against the wrongdoer by an ordinary civil action and recovers compensation in the shape of money damages if he succeeds. This is what he concludes. So you find that discussion on criminal justice in continental European country, or discussion on criminal justice in primitive continental European country, cannot have any parallel in our ancient Indian society. Meaning thereby, of course, greatly, fundamentally, and basically different societies, different legal institutions, and of course, different ideas and different procedures as far as criminal justice is concerned. Now I would be a little more specific as far as criminal justice in primitive Indian society is concerned. I already spoke on certain specifics, or the characteristic features. I would be little more specific on that. And then we'll move to criminal justice in India in the postmodern era. Now you have to understand that our criminal justice system has not undergone any substantial change in the last at least 200 years. Has not gone any substantial change. And that makes our criminal justice system today appear primitive. That is something that I need to highlight. That is something that I want to highlight as far as this discussion is concerned. And this is exactly what I want you to appreciate. I'm facing some connection issue. Am I audible? It's showing that my connection is unstable. Um, am I audible?
Yes, sir, audible.
So you're perfectly
Okay,
audible.
okay, all right, all right, all right, all right, all right. So when you look into the smritis and other politico-legal texts, you are convinced that in India, a well-organized legal system existed in ancient times. The concept of dharma in Hindu mythology uh, that clarifies this view further. Dharma. The term is derived from a root signifying to sustain and to discipline to rule. And on the back of this dharma lays the concept of justice, which sustains society by disciplining and ruling the errant passions. What else the law does? Doesn't law, even in the modern societies, arbitrate the conflicting interests, resolve the conflicts amongst the individuals, between the individuals, or between the state and the individual? The Smritis record the precepts for administration of justice, the rules, the propositions. In chapter 7 of Manu Smriti is a much abused book, of course. I'm not recommending that anyone should, but the one, even if you don't like the word or the title, of course, you have to listen to. Of course, you have to be a little more tolerant to at least listen to what is there, or try to read what is there. Not everything is good about Manusmriti, but if you find something which is of relevance to our topic of discussion, certainly that must be quoted. Chapter 7 is especially important for this, where you find the glimpses of a modern legal system. I spoke generally. Now I'm speaking specifically, focusing on Manusmriti. Here also, you would find that the king or the ruler is mandated to act judiciously in protecting his subjects. And it was expected of the subjects that all shall abide even by a bad law made by the king. Bad law made by the king. Remember what Austin said, law is command of sovereign. In his idea of law, and Austin by any standard is a modern legal philosopher, a modern legal jurist. His idea of law is devoid of any moral content. He said that, okay, whatever has been said by, whatever has been pronounced by the sovereign as law is binding. Don't question about its immorality. Manu also had the same idea. Abide by the law, even if it's bad. Punishment was retributive and served as a deterrent by its severity. Was retributive. When you read the decisions of the Supreme Court on a punishment, you'd find that the object of retribution and the object of deterrence is recognized as a valid object of punishment even today. In several catena of cases, the Supreme Court has said that the deterrent effect or the retributive object of punishment can't be lost sight of. And it would be travesty of justice if in a crime which has revolted the conscience of the society, has created great alarm in the society, is leniently dealt. And the penal policy in the society that Manu talks about in his Smriti, ancient Indian society, of course, was based on the consideration of place, period, capacity to inflict the punishment, and the proportionality, just deserts, that principle of just deserts. And Manusmriti says that a well thought after punishment increases the affinity of the subject towards the king, and a punishment without just cause leads to all round destruction. I was reading this judgment, which I thought that I must um, uh, request you to also read. It's a 2017 judgment of the Supreme Court. Let me find the citation. It's Suresh Chandra Jana versus State of West Bengal. Suresh Chandra Jana versus State of West Bengal is 2017 16 SCC 466. It's a division bench. It's a division bench judgment. It's a case of brutal rape and ultimate death of the victim. And Justice N.V. Ramana, who is the present Chief Justice, has made a very interesting and very, very illuminating observation about the state of criminal justice in today's India. In para 2 of the judgment, you would find this statement. And I quote, "A word on criminal justice system before we deal with other aspects of this case. Criminal justice system is not only about infrastructure or surveillance, rather it is how we protect our countrymen. It is how we recuperate after loss. It is how we show faith in our constitution and how we uphold the values of justice, fairness, and equality." And he further says that there is no dispute, there is no disagreement that our criminal justice system is a complex one, which is administered at various levels of government and fashioned by a range of actors. And he further says that when such a complicated system is in place, a system like ours, there is a requirement for higher discipline at every level. And Justice Ramana says that I'm of the opinion that traditional roles played by the stakeholders in criminal justice system would bring revolutionary changes if there is an increased awareness of the victim's rights. He acknowledges that the Indian criminal justice system, the modern Indian criminal justice system, is complex. In chapter 8 of Manusmriti, elaborate discussion on administration of justice can be found, and it not only contains the rules for the conduct of the business of the courts and the rules of evidence, it also prescribes punishment for theft, for example, breach of trust, perjury, breach of contract, adulteration of food, environmental offenses. You would find that how even environmental offenses were punished. Manusmriti contains elaborate penal provisions for sexual offense against women and prescribes enhanced punishment for repeat offending. Primitive by the standard. Enhanced punishment for repeat offending is what the Indian Parliament prescribed in 2013. Remember, 376 capital E. Even death for repeat offending, where on earlier occasion the accused was found guilty of any of those offences which have been enlisted in section 376 capital. Manusmriti lays down penal policy in deciding the quantum of punishment and underlines the importance and objective of punishment. It says that a king who punishes an innocent and fails to punish the guilty gets infamy. Isn't that a feature of a modern, rather postmodern society? Even the king was not above the law and deserved more severe punishment for the same offense. King was also not above the law. Rule of law. Remember what Dicey said. Rule of law and not rule of men. There would always be men at the helm of any man-made institution. But the law is above them. Other smritis too contain elaborate precepts on crime and punishment. Even in Kautilya's Arthashastra, almost all the modern concepts of crime, criminology, penology, and victimology are visible. In 2017, Justice N.V. Ramana talks about the plight of the victim and recognizing the rights of victim, of course, to make criminal justice system more inclusive in Suresh Chandra Jana case, the 2017 decision. In Kautilya's Arthashastra, you would find the glimpses of victimology. It was Kautilya, it was Chanakya who initiated the discussion on the role of secular law as a complement to the then existing measures. He believed that positive or secular law without ethical anchoring was unlikely to have positive outcomes. He was talking about what Hart later said, the moral content in law. But then, unlike the postmodern societies, including ours, Kautilya assigned a higher priority to deterrence than to corrective justice. He may be credited with the initiation of monetary sanctions, He suggested compensation to the victims for all financial losses, but only for serious physical injuries caused due to negligence. You look into the discussion on restitution and reparation, and you would find that how insightful the ideas of Kautilya were. But that doesn't mean that the rules and principles and precepts were absolutely free from vices, especially in Manusmriti. Caste-based discrimination is rampant. Caste-based discrimination in deciding the quantum of punishment is the most glaring, is the most, I think, which is a blot the entire on the entire system. Now this has to be kept in mind. I repeat that the texts on criminal justice in ancient European societies, or texts on criminal justice in other societies in different parts of the world, would not help you in understanding the criminal justice administration in ancient India. For that, you need to refer to the Indian texts. Max Muller translated, of course. Max Muller, the German intellectual. He translated almost all the ancient texts. But then it's only translation. It's not about a commentary, or it's not about, of course, there are certain explanations offered by him. But if you want to understand the criminal justice in ancient India, you have to refer to the works by Rama Joyce, you have to refer to the works by uh, certain other legal historians, M.P. Jain, of course, V.D. Kulshrestha, of course, in certain works of V.D. Kulshrestha, especially his work on legal history, M.P. Jain's work on legal history. You'd find these discussions and references at one place. Now, coming to the criminal justice in postmodern India, in fact, the title reads Primitivism to Postmodernism. Primitivism to Postmodernism. So let's first see what postmodernism means, and whether any discussion on criminal justice in India is possible in that respect. Postmodernism, as you may already know, is an intellectual stance or mode of discourse which challenges worldviews associated with the Enlightenment, which dates back to the 17th century. Postmodernists are skeptical of explanations which claim to be valid for all groups, cultures, traditions, or races, and instead focus on the relative truths of each person. criminal justice systems are being studied in the light of these attributes of postmodernism, where, as I said, and let me repeat, the postmodernists are skeptical of explanations which claim to be valid for all groups. I remember when I was participating in a certain discussion and debate, and I used the term Indian society. Indian society. I was very rightly objected to by one of the discussants. Which society are you talking about? Which society do you refer to the Indian society? That's postmodernism. And they are skeptical of claims which we believe are valid for all groups, cultures, traditions, races, and focus on the relative truths of each person. Postmodernism considers reality to be a mental construct. Isn't criminal law differently administered in different circumstances? Isn't its administration still primitive in its outlook? I can cite n number of cases where you would find that how the Supreme Court as a whole or individual judges expressing their individual opinion have lamented that the criminal justice system in India is on the verge of collapse. So when the criminal justice system in India is on the verge of collapse, any discussion of criminal justice in India in the context of postmodernism is not possible. And even if we have it, that would be very, very shallow. That would be very, very shallow. And that would be very pretentious. Let me make it very clear. So the legal institutions, the laws, the procedures, and those who are responsible for administration of criminal justice, they all have a very, very primitive mindset. Laws have primitive content. People who administer these laws have primitive mindset. I'll give you an example. Very a simple example. These are the times when the entire atmosphere is political, in our state at least. Elections are being held. The last phase would be on 7th, and you would have a new government on 10th. Look at the political discourse and the political adversity around you. It's not necessary to be a political person in order to appreciate what is happening. My idea is not to discuss anything which is political in nature and happening around you. My idea is to draw your attention to something which we often take for granted and see as permissible. Suppose there is a rally organized by the ruling party, whichever is the ruling party, and a political leader is to address that. Certainly, the opposition parties would have a right to protest if they are not satisfied with the measures, welfare measures, whatever. Since the days of our colonial masters, any showing of black flag to the leaders in power would be crushed with the highest degree of brutality by the police. Those who wave a black flag, they are merely registering their protest. And there is nothing in law anywhere which bars a person, especially in independent India, which swears by constitutional freedoms and rights, from expressing his dissent, from registering his dissent in a peaceful manner. And no one ever raises any voice. That's primitive. The institution that you today call police was made by the Britishers at around the same time when Sir Henry Maine was writing that ancient law, or ancient law was published in 1861. The Police Act is of 1861. The CRPC is of, the first CRPC was of 1861. The IPC is of 1860. The CRPC of today, that is CRPC of 1973, is a mere replica of a CRPC of 1898. Even the sequence is the same. Sequence of the sections is same with some modifications and ornamental changes. The institutions, the laws, the prisons are administered and are being governed by a law of 1894. 1894. The prison manuals of different states are also primitive, I must say. So when your laws are primitive, when your institutions are primitive, when the stakeholders have that primitive mindset, any discussion of criminal justice in India in the context of postmodernism is something that would not be worth our time and energy. We, as a criminal justice enthusiasts, or we as an important player and stakeholder as far as criminal justice, can only hope that the laws, the rules, the regulations, the institutions, and the people, they imbibe the core values of a postmodernism, and we have a criminal justice system which is modern in every respect, in every aspect, and that is what we can wish for our legal system. So I'm done as far as this discussion, criminal justice in India, primitivism to postmodernism is concerned. Certainly, different uh, perspectives are there, meaning thereby a different person would have a different perspective on this issue. And thankfully, I had that liberty of putting forth my own perspective and my own ideas as far as this topic is concerned. Um, Thank you for listening with patience, and we still have 10 minutes time. So if you have any question, or you want to make any intervention, or you want my opinion on certain other issue, as far as criminal justice system or criminal justice administration in India is concerned, just unmute yourself and I'll try to answer that. But otherwise, I'm done. Only yesterday, in fact, I understand that you would not be asking any questions. Only yesterday, I was having some informal talk with Professor B.B. Pandey, the stalwart as far as criminal law scholarship in this country is concerned. And he told me that how in Indian universities and institutions, uh, the discourses on criminal law are purely legalistic. We are only concerned with knowing what is there in Section 378, what is there in Section 379, and never critique the desirability of having such kind of provisions. The reason which I understand of this purely legalistic approach is that uh, you have to practice the law as it is in the law books, in the statute. So you can't be critical. But who stops these legal institutions, these educational institutions, these institutions of higher learning, which uh, must encourage fresh ideas and fresh perspectives, from having some uh, more critical evaluation of these laws, institutions, systems, and practices is a mystery for me. तो अगर आपका प्लान है पीएचडी करने के बाद शिक्षक बनने का, और आप में से कुछ जो है वो क्रिमिनल लॉ पढ़ाने की इच्छा भी रखते हैं, तो सर्टेनली यू हैव टू लुक बियॉन्ड व्हाट यू फाइंड इन द टेक्स्ट बुक्स. मयूरी जी ने मुझसे पूछा था पिछली बार, मेरे लिए बहुत बड़ा एक चैलेंज होता है जब मुझसे लोग कहते हैं कि आप रीडिंग दे दीजिए, कोई एक रीडिंग हो, in spite of uh, my willingness, it's often very difficult for me to uh, give you one single reading that you would be sort of referring to. And but still, I Mayuri ji, I remember my promise, and I'll certainly be sharing some reading. And that's it. That's all from my side. It seems that everyone is away, and
I
yeah,
also Mayuri ma'am.
great, 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 great.
So thank you so much for your enlightening lecture. Thank you so much.
Thank you so